Hi, and welcome to What's the Tea in L&E. I'm Leah.
I'm Emily.
And we are management side employment attorneys with Woods Rogers. Emily, let's talk about some really divisive things going on in the world right now.
Oh boy.
Yeah, I've got two of them for you.
Okay, great.
One is we know that this Kendrick Lamar and Drake feud is at an all-time high. Okay? As we saw in the Super Bowl, front and center for the world to see, those two are at it. Okay? The other very divisive concept that everyone is talking about is this executive order that President Trump issued within his first week of office that basically says the federal government is to only recognize two sexes. Tell me about that.
Yeah, well, putting aside my strong personal feelings on the Drake versus Kendrick Lamar debate, so this executive order I think is creating a lot of confusion for employers because, for years, employers have been schooled on how to not discriminate against employees and how to treat everyone fairly and the same. And there's been a lot of talk about gender identity and respecting that in recent years. And now there's this executive order. And what does that really mean in light of everything else? Well, I'm going to start off by saying this executive order is President Trump's direction to the federal branch, to the federal agencies that he's in charge of. He's telling them what he thinks sex and gender should be.
Now, what's interesting about this is we have to bring this back to civics class, right?
Yes.
Because we have from the legislative branch, right? We've got three branches of government: executive, legislative, judicial. So we have Trump saying that the federal agencies are only supposed to recognize these two sexes, and those are biological birth, assigned at birth genders. And then we have the legislative branch, Congress, and they passed Title VII of the Civil Rights Act in 1964. And in it, they said that that it is unlawful to discriminate against someone on the basis of sex in the workplace. And so they didn't necessarily define sex, but we have that law is still in existence. And then that brings me to the judicial branch, who actually defined that term sex recently in a case of Bostock versus Clayton County.
Absolutely. So Congress, as like Leah said, we have Title VII, protecting people from discrimination on the basis of sex. A few years ago, the Supreme Court said sex includes gender identity. So you cannot treat people differently or treat them worse because of their gender identity. And so that provides protections for transgender individuals in the workplace. Now, that's a bit different from what the Trump administration is saying, because federal agencies are now directed to only recognize the biological sex assigned to someone at birth. That means whatever gender a person may identify with later in their life, the federal government is being instructed not to recognize that. Now, does that change Title VII, Leah? Does that change statutory law?
No, it does not. Title VII of the Civil Rights Act is still in place. It is unlawful to discriminate against someone on the basis of sex. And that executive order also, Emily, does not overturn Supreme Court case law, Bostock versus Clayton County, which says that sex includes protections on the basis of gender identity. Therefore, based on those two branches of government, we have the concept that it is still unlawful to discriminate on the basis of gender identity. That said, what does all this mean then, right? So if the Trump administration has directed federal agencies to do this, what does that mean for EEOC? What is our Equal Employment Opportunity Commission going to be doing over the next 4 years?
Absolutely. So that's the part of this that you really want to know if you're an employer. This directive has changed the EEOC and the Department of Labor's directives and how they're going to enforce the law significantly. We will see how their enforcement shakes out, but this is a big signal. So some of the former EEOC and former DOL priorities are simply not going to happen anymore. And we'll have to see what the EEOC does with discrimination complaints from individuals who feel that they were discriminated against on the basis of a gender identity that the EEOC has now been instructed not to recognize.
So, well, another takeaway for you guys on top of monitoring that, right, is this idea that the law just sets a baseline, right? The law just says don't discriminate on the basis of sex. And we know that includes gender identity based on current Supreme Court case law. But you as an employer can set a policy, a requirement that is higher. You can set a higher threshold than what the law requires. You can say that it is still unlawful in your workplace or is still against your workplace policy, anti-harassment, anti-discrimination policy for individuals to mistreat each other on the basis of someone's gender identity, to misgender them. So you can take a stronger approach. And I'd recommend you always bring it back to respect and civility. And no executive order, no Supreme Court case can take away your right to ensure that your workplace is respectful and that employees continue to be civil and professional with one another, and that these concepts, like someone's gender identity, don't impact somebody's ability to get a promotion or someone's ability to maintain their job or to be treated fairly in the workplace.
Absolutely. We recognize this is a changing legal landscape. If you have any questions at all, if you have an instance that comes up, perhaps particularly if you're a federal contractor, get employment counsel involved to start analyzing some of these issues as this field continues to evolve. But thanks for joining us today. We'll see you next time.